Good morning, everyone. I'm Mike Danaher. I'm an Assistant Attorney General with the New York State Attorney General's Office, and Attorney General Tish James is the Attorney General, new Attorney General for the state of New York. And we're going to talk today at our monthly consumer issue program about an issue that is very popular, and it's called landlord and tenants' rights and responsibilities. And I know it's an important topic because most of you are here that I haven't seen you before. And it's good to have everybody here. We encourage you all to come out here. Just as going into this, a preface is we are at Cornell Cooperative Extension on Willow Avenue every month talking about a different consumer-related topic on the second Thursday of the month at 11 a.m. So we would encourage you all to come out. The topic changes from month to month, although we know this one is such an important topic that we actually do it twice a year. So we're going to talk about the general rights and responsibilities that both parties have when it comes down to residential real estate. First thing that I want to talk about is just the whole foundation of this, and that is what is a lease? A lease is simply a contract between two parties, a tenant and a landlord, to rent, to give up use and occupancy of residential property, in consideration of which the tenant is paying a fee, which is the rent. It's not any otherwise well defined other than it is a contract. It's a contract between the parties. Somebody will say to me when they call, I'll ask them, I'll say, do you have a lease? And they'll say, well, no, I don't. Well, really they do, because the lease is actually the agreement itself. It doesn't necessarily have to be in writing. Now disregard what I just said. For both landlords and tenants, it is in everyone's best interest to have everything in writing. So, no, the law doesn't require there to be a written agreement as long as it's for a year or less. But get one in writing anyway. Some would say, well, it's only going to be month to month and it's just going to be a short thing. You can still put that in writing. You still get it in writing. I will tell you that most of the complaints that come into our office related to leases could easily be resolved if the parties had put it in writing. I'll give you an example. I moved in and it snowed, it was wintertime, and the landlord never cleaned off the driveway or cleaned off the sidewalk. And then the landlord says, well, that wasn't my responsibility. And the tenant says, well, it wasn't my responsibility. But if they had had something in writing, and the writing said tenant responsible for all snow removal, yard maintenance, or whatever, that issue could easily have been identified. And then if the question comes up related to a lease, and somebody said that he or she was supposed to do this, he or she was supposed to do that, somebody just pulls out the agreement. And it says right in there who is responsible for what. Who was responsible for utilities? Who was responsible for water? Who was responsible for maintenance? Who was responsible for anything in particular? So, although not required necessarily by the law to be in writing, you would be well served, whether you're a landlord or a tenant, to put it in writing. Even though it's going to be month to month, you can put down month to month. There's certain rules we'll talk about in a minute about how month-to-months work. But if you put it in writing, you're going to save yourselves a lot of hassles. So I encourage everyone, landlord or tenant, put the agreement in writing. Put down everything that is going to be associated with this in writing. Now, where are the laws that are related to landlord-tenant? They're all over the place. We have in New York, we have a real property law, a general obligations law, a real property actions and proceedings law that deals with evictions, we affectionately refer to as the RPAPL. And we have the multiple dwelling law. There are municipalities that have different rules regarding housing and certificates of occupancy. So it's all over. It'd be nice to be able to go up to a shelf and just pull off one book off the shelf and say, okay, here it all is. But it's all over the place. So what we hope to do today is to talk about what the responsibilities and obligations of both parties. We're not going to just say, well, the tenants have these rights or anything. This is a mutual agreement between the two sides. So we have to talk about what responsibilities does the tenant have? What responsibilities does the landlord have? What obligations does each of them have? And in their relation to each other. So let's start off by talking about the landlord's obligations. What are the landlord's obligations? The first and foremost obligation that the landlord has is to provide a habitable residence. That means it has to be livable. There's no real definition of what livable means, but I think in probably 99.9% of the cases, all of us here in this room could agree on what would be a habitable or non-habitable issue. And habitability means exactly that. You can't live in it. So if a tenant comes to our office and complains and says, well, it's not habitable because the carpets are dirty. Well, you can still live there. It may not be pleasant, but you can still live there. So it depends on how bad it is, whether it rises to the habitability. Is it livable, safe, and sanitary? So does it meet that threshold? And if the tenant continues to reside there, it's harder to make the argument that it's uninhabitable because they're habitating it. So that's the obligation. There has to be heat and hot water. It has to be water. Water, heat, and hot water. Not much else. Rodent, varmint free. That it's otherwise safe. If the landlord does not live up to his or her obligation of a habitable residence, this is how the contracts work. Contracts work that if a party to the contract breaches their obligations on the contract, the other party is absolved of their responsibilities to fulfill that agreement. So let's assume for the moment that it is an uninhabitable residence, not livable. There's a fire, not due to the tenant's fault. It's just electrical problem. That then makes it uninhabitable. That breaches the landlord's duty to provide a habitable residence. That absolves the tenant of their obligation to continue residing there and being responsible for the payment of future rent. So when somebody is faced with this uninhabitable obligation, what can they do? Well, one opportunity, and I know it's not realistic, but I throw it out there anyway, which is the tenant could sue for a reduction in the rent if it's partially uninhabitable. What tenants sometimes do is they stop paying the rent. And I'm not a big advocate of stopping the payment of rent because you are buying yourself a lawsuit. You're buying being sued to remove you, evict you from the premises. And once that starts, there's really no going back unless the two parties resolve it by agreement, because when the eviction takes place, you either win or you lose. And if you lose, you don't get a lot of time to get out. So I really don't usually advocate for that. Or at least what the tenant should do is find out what it would cost to fix whatever makes it uninhabitable. Let's use the classic example. The furnace doesn't work anymore, and it's January. What does the tenant have to do? Well, the tenant can investigate. If the landlord doesn't do it, you always contact the other side. If landlords have a problem with the tenant, get a hold of the tenant. If the tenant has a problem with it, get a hold of the landlord. It just makes common sense you try to do that. We're talking that we're past that. And so what would happen? Well, the one thing a tenant could do is if they can show that it's uninhabitable, they could get out of their lease. Sometimes that's not realistic, that they don't have any place to go or something. So another opportunity might be check with reputable furnace repair people to find out what the cost is. Get an estimate for the repair. If it's an emergency situation and you get the repair, keep a copy of the receipt. And what I would say is that you turn the receipt over to the landlord, keep a copy for yourself, always keep copies. Keep a copy for yourself. And let's say, I'll just use numbers. Let's say it was a small repair. Your rent is $600 a month, and the repair is $200 to have somebody come out and fix the who's it, what's it, and it gets fixed and it's working. What I would say is the next month, you hand a copy of the receipt for $200 to the landlord, along with your $400 check, and say, I've paid you the money. And then you got a better chance with the landlord saying, well, you owe me an extra $200 because you didn't pay the rent. So I paid to have the furnace fixed. And they'll say, well, I'm going to sue you to evict you. Well, that's their right. They can try and do that. But when you go to court, you can say, Judge, here's the copy of the receipt I gave him for $200 to fix the furnace. And here's a copy of my $400 check. I did not fail to pay rent. I paid it. The only thing to be careful of is make sure that it's a habitable issue. If you hand them a receipt for $200 to have the living room repainted, that might be a different story. It would have to be a habitable situation. So that's usually what I suggest, is that rather than just holding the rent hostage, I'm not paying you $600, I'm not paying you anything till you fix this thing, you're much better off trying to figure out how much it's going to cost to fix. And then say, well, let's say it's $1,200 to fix the furnace. You say, I'm not paying you. You send them a note. I'm not paying you the $600. Here's a copy of the receipt for the $1,200. I'm not paying this month, and I'm not paying next month. I've actually paid the rent by having this fixed. I think at least when you would go into court in an eviction situation, you'd be in a much better position to be able to show that going along the way. So if there's an emergency and you need to absolutely have it done, you can make the repair, deduct it for the rent, and keep receipts. I always try to contact the landlord first. One general barometer of uninhabitable is code. If there's code stuff that makes it uninhabitable, there are code violations that might not make it uninhabitable. They're not meeting this technicality or that technicality. But it's kind of a good general framework. Landlords, let me talk to you about this. And that is, if you get contacted by a tenant for some habitability issue, something's wrong, something's broken, you have an obligation as a part of receiving rent and being paid for it, is to get on that. And the way I like to tell landlords is treat it as if it's your own house. If you were living in that place and you didn't have heat, what would you do? And that's the way that you have to treat it. You have to get on this thing. You don't have until after you go to your grandchild's sporting events. I'll worry about it then. You wouldn't have done that if it was your house. Treat it as if it's your own. That will answer a lot of questions. Because the thing comes up is, how long does the landlord have to fix something? And I'm going to tell you something that you're going to hate. Because the answer is a reasonable time. Oh, what's that? I'd like to know if it's 6 hours, 12 hours, 24 hours, 48 hours. And I tell you that reasonable is a great term. It's it works very well because, first of all, every one of us here, I think without exception, can say they're a reasonable person. So most of us here can define what's reasonable. And that is, I'll give you two scenarios. Let's assume, I'll change one fact. Furnace is gone. Your furnace broke down. And the one fact I'll change is, what if the furnace broke down on July 1st? How long would the landlord have to fix it? Let's change the facts. What if it's January 1st? Wouldn't we all agree there'd be a lot more time to get a furnace fixed on July 1st than it would be on January 1st? So reasonableness, I mean, you could say, okay, on January 1st, it's got to be fixed within 3 hours. On January 6th, it's 2.5 hours, and you could do it, but it's a reasonable time. And I think that we could all agree in most instances what a reasonable time would be. What are some other things? One thing we get question-wise is, who's responsible for other tenants in the building being noisy and parties at 3 o'clock in the morning in a multiple unit building? And the landlord is not necessarily in control of that. You obviously will notify your landlord. My experience has been, you have a 4-unit building. One's up till 4 o'clock in the morning, partying it up, loud music and the whole thing. The reasonable landlord is not going to let one person get away with something like that when they have the potential to lose 3 other tenants because of it. So that good landlords, and the vast majority of people are good landlords, they have an investment in this property, and they will help take care of the situation. But how do you handle it in the immediate instance? And that is, how would you handle a situation if you owned your house and the neighbor next door was having parties at 4 o'clock in the morning? You call law enforcement. If you have to, let law enforcement into the building. If it's a common entryway and stuff, say, hey, this racket is going on here. That's how you would normally have it. But again, inform the landlord. Some have argued that constant noise in the middle of the night, partying up like crazy, could amount to a breach in the warranty of habitability. I don't know that that issue has been tested yet. But I know that landlords, for the most part, are interested in knowing that sort of thing. And if they're disturbing to all of the tenants, then they're usually going to take care of it. So they have that obligation to offer a habitable residence. What protects the landlord in the event that a tenant should cause damage to the premises or not? Because one of the fundamental obligations of a tenant, one is to pay the rent. We all want to pay the rent, pay it on time. Tenants, landlords have expenses. They've got taxes, they've got insurance, they've got, in some instances, utilities. If they're paying the utilities, they have an obligation themselves. They have financial obligations. They're trying to protect their financial interest in the premises. They are entitled to receive the rent on time. If you don't pay it on time, I know there's extenuating circumstances. So, the only way I'm going to get to work is to get my car fixed. I don't have the money for the rent this month because I got to get the car fixed. That's not the landlord's fault. The landlord is entitled to receive their rent. No excuses. It has to be paid. It has to be paid on time. In addition to the paying of the rent, the tenant usually pays a security deposit. And a lot of questions revolve around security deposits. In fact, we get so many questions about security deposits that our office actually has a separate security deposit complaint form. We get so many complaints about returns of security deposits. We have our own separate complaint form that just deals with security deposits. Let's talk about how the security deposits work. If you know the answer to one fundamental question related to security, if you know that answer, you can probably answer for yourself every question related about a security deposit. And then that main question that you need to know the answer of it, and many of you probably already know it, I'll ask it anyway. Whose money is the security deposit? Is it the landlord's money because they paid over? Or is it the tenant's money because it was their money giving? Maybe you know the answer. Whose money is the security deposit?
Tenants.
It's the tenants. You all know that answer, right? So if you know it's the tenant's money, you can answer most questions related to the handling of security deposits. Okay, so the first question is, if the money gets deposited into an interest-bearing account, who gets the interest? Why? Why does the tenant get it? It's the tenant's money, yes. So that's the easy answer. Now, this is more an academic discussion than it is a practical discussion. It was more practical 20 years ago when I was talking about this sort of thing. But I don't know if many of you have looked at the interest rate you receive on your savings accounts. But back in the day, I'm getting to that age where I can start talking about back in the day. Back in the day, savings accounts were paying 3% interest, 2-3% interest. The law allows the landlord to retain 1% as an administrative fee. Anything above that, it's the tenant's money. So in essence, the landlord can get paid for managing the interest and managing a security deposit. But I know in a lot of instances, landlords do not even charge that because it can be an administrative nightmare to split everything up. And they just give the security deposit back. But here are the rules. First of all, there is no law, some people will be surprised. There is no law as to how much the security deposit should be. Some would think because it is so common that there's always 1 month's rent as security deposit. The fact remains is there's nothing in the law that says that. It just has kind of worked out as custom that is what it's for. So there is no set amount. It could be 2 months rent. It could be a set flat rate, $1,000. It could be whatever. So there's no set amount. The landlord has to understand that security deposits are not additional rent. In other words, we have seen circumstances where landlords don't want to give security deposits back so that they come up with some weird fangled explanation as why they should be entitled to it. And there's a reason for that, because the landlords could be violating law. If the landlord receives a security deposit, let's say you give it in cash. You give them $1,000 in cash as a security deposit. Can the landlord take the money and put it into his personal checking account? Anybody know the answer? I see some heads shaking. If you're shaking your head, why? Why can't? I mean, he's keeping it. He's keeping it. It's the security deposit. Why can't he put it in his personal checking account?
It's not his money.
It's not his money, so he cannot put that. You cannot, landlords, commingle security deposit money with your own personal funds. We can take it to the extreme. You hand him $1,000 cash, and he takes out the wad of money that some tenants think that landlords always have, is this big wad of money, and puts it on the wad of his own money. That's commingling. That's putting it together. Now, maybe he should put it in the other pocket or something, but you're not supposed to commingle. Why? I think my own guess is that the legislature, rightfully, in setting up what the law was, said, you know, psychologically, when we put money in our account, it becomes our money. So that our mindset is when it's time to give it back, we're giving back our money to the tenant. So to avoid that whole thing, we cannot commingle money from a tenant. What the landlord should do is get a separate bank account, we can call it landlord trust account or whatever, and put only security deposits in that account. So that it's much easier when the lease is over with to pull money out of that account, not my account, that account, to give the money back to the tenant. So it cannot be commingled. Get a separate trust account. It's very simple. What's the landlord have to do? The landlord has to treat that as if it is not his or her money, and then at the end of the lease, give that back. I'm of the view also that, you know how sometimes people have to pay the first month's, the last month's, and the security deposit. My view is that the last month rent is there to secure the last month payment. Therefore, must be deposited in a trust account until that last month occurs. And if whatever minimal interest that money is accruing, it should belong to the tenant. And tenant be given credit for that. And then the money could be used at in the last month. So, understanding that the money in the account is interest bearing. Who gets the interest? The tenant gets the interest. There are some stricter requirements, and that is, if the premises consists of 6 units or more, you must put the security deposits in an interest-bearing account in a New York financial institution or a foreign financial institution that has a branch in New York. It's got to be placed in that account. If there are 5 units or less, it's not required, but the underlying rule that the money cannot be commingled is still in place. So you cannot commingle. If the property is sold, what happens to the security deposit? Well, the security deposit, and this is to landlords who are selling their properties, you make sure that when you sell that property and the money's transferring from the buyer to you and you make sure and you keep a record that that security deposit money was transferred over. And those of you that are buying an existing residential rental property, you make sure you get that money when the transfer takes place. And sometimes it happens, it usually happens in the exchange of money. Anybody's done a real estate deal, things are flying all over and money's, there's credits back and forth and all that. There should be a credit or an actual transfer of cash from the security deposit over to the buyer. And buyer, if it's in the numbers, you have to take the money out of the deal. You have to take the actual cash out of the deal represented as tenant security deposits and put it in a separate account. If sellers of rental property, if you don't ensure that that money went over, you are still on the hook. You're getting rid of the property. Why do you still want to be on the hook? Make sure it goes over. Make sure you have a record of it. Make sure you keep a record of it so that if the tenant then comes back to you and says, I moved out, where's my security deposit? You can say, okay, here's my proof that I actually gave it to your new landlord. New landlords, you're going to get in trouble if the money was transferred over to you and you didn't put it aside, because then you've commingled. So make sure that gets taken care of. I know when I've done previously in my prior life in private practice, when I did several of those transactions, I made sure that money, if I was representing a seller, made sure the money went over. So I was representing a buyer, I made sure that they received the money, and I made sure that my client put the money aside so that it could be used later. What can it be used for? Security deposits are security, and that's it. It is to secure a return of the property, and this is another obligation of tenants, that the property is returned in the same condition it was received, here's this term again, reasonable wear and tear accepted. Meaning it's got to be turned over in the exact same condition as you received it, except for some things can wear out. Now, Granted, if you're only there for a year, less things wear out than if you were there for 5 or 10 years. But if things wear out through the normal course of use of a reasonable person, and things wear out, that's not on the tenant. That's on the landlord. Landlords out there, I see this happen all the time. They seem to think that they have to repaint every time a new tenant comes in. Whether they do or don't, I leave that up to the landlord. But to charge a tenant for having to repaint, but the repainting was due just because of normal use of the premises, that's a cost of doing business for the landlord. The landlord has to cover that. If it's damage, holes in walls that have to be repaired, those sorts of things, holes that have to be fixed and then painted over, yeah. But repainting the entire apartment when someone hasn't done anything, because it's been a while since it got repainted, that's a cost of doing business and should not be charged to a security deposit. Again, I think most of us can agree what is reasonable wear and tear. You know, just because you have kids who are aspiring artists and they take Crayolas to the wall and you say to the landlord, well, you knew I had a 2-year-old, and 2-year-olds do that stuff. That's reasonable wear and tear. It is not. If there is damage, has to be repainted, that goes against the security deposit. Now, tenants understand that the security deposit, as we talked about earlier, is an arbitrary number. That doesn't mean your exposure is limited to the amount that you paid as a security deposit. College students thinking, man, it's the end of the semester, we're going to have the biggest blowout that we ever had. And frankly, we're probably losing our security deposit anyway because we've had a few parties along the way too. We're going to have a big blowout. What the heck? Our security deposit's gone anyway. So we're going to move. Your exposure is not limited to what the security deposit was. Your exposure is limited to the amount of damage that is caused. And if you cause damage in excess of what was paid as the security deposit, the landlord has every right to go after you to recoup the money that was caused damage-wise. And for those of you parents out there of college students, be very careful when you co-sign on their leases, because by co-signing, you are also co-signing to any obligations, which also is that obligation to return the property in the same condition it was received, reasonable wear and tear accepted. I have had instances where parents have had to dip into their pocket for thousands and thousands of dollars because of damage that was caused to an apartment. Just a word to the wise, that is the limit. We had a question about security deposits.
Yeah, well, I mean, the exposure of parents, don't they have that exposure until the children are 21 years old?
Doesn't the parent have that exposure of responsibility if their child is less than 21? And the answer is potentially they do, except I would make the argument, I didn't sign on to the lease. They were out on their own. I furnished them a home here in wherever, and therefore that's on them. It's not, I furnished the necessities for my child, and that's the argument I would make. Whether it worked, I don't know. But let's assume for the moment that the child is a senior and is over 21 when they leave the premises. No, that's not the case. Here's the other thing is I made this suggestion to my children as well, as far as when they were going out on their own, is renter's insurance is very inexpensive, relatively speaking, very inexpensive. Understanding that renter's insurance covers liability, meaning if the tenant does something that causes someone to be injured, then they have some insurance coverage. Understand that all contents of the apartment, their computers, their televisions, their all kinds of stuff that they have, clothes, things like that, is not covered by the landlord's insurance policy. Get a renter's policy so that if there is damage, theft, things like that, you can get coverage for. Not tremendously expensive. should inquire about those sorts of things to help protect your stuff. In case that there's some calamity, the insurance for the landlord only covers the structure usually and the fixtures associated with that. So again, tenants' obligations: pay the rent, keep the property up. Both parties must fulfill whatever their obligations are under the lease, and that's the written agreement. Who agreed to do what, they're responsible. We have a question.
Yes, so if you go to your landlord and you say, well, my table got damaged because there was a leak in the wall.
Personal property was damaged because of the leak on the,
structure.
in the structure. I would say that you would be looking at the landlord and the landlord's insurance company for damage that is caused as a result of the landlord not fulfilling their obligation. So what a typical, I'll say homeowners, in this case a landlord's owner's policy would cover would be any damage as a result of something in the structure. I actually had a situation where we had water pipes freeze, and the water pipes froze not outside of the structure of the house, but within the structure of the house. And my insurance policy covered anything that occurred inside. So that type of thing would be fall under the landlord's policy. But here's the better side of it. If the tenant had coverage, we don't really care.
Right.
You know, the tenant would still be covered under their own policy for their damage, and let the insurance companies fight it out.
But doesn't that
Hold on one second.
So your response is to say, the tenant can say to the landlord, how does the tenant know what's in the landlord's policy?
That's right. You go to the landlord and you say it, but you could also just turn to your insurance carrier and say, I had damage to the table. Here's the whole circumstance surrounding it, and let the landlord's insurance carrier and your insurance carrier fight it out. I mean, that's why we pay premiums, right? That's why they. Next question.
But the landlord has a reasonable amount of time to fix that leak?
The landlord has a reasonable amount of time to fix the leak. That is correct, but that doesn't mean it absolves the landlord of the responsibility for the damage that leak had caused. Okay? That we're talking about two separate things. As far as the habitability issue of it, the landlord would have a reasonable period of time within which to fix that, therefore keeping the tenant in the contract. If the landlord doesn't fix it within a reasonable period of time, that severs the contract and the obligations of the tenant to pay any further rents under the agreement. Next question.
You said the tenant has the responsibility to pay the rent and to maintain the property in the condition that they received it.
Correct.
Less the normal wear and tear.
Yes.
And other responsibilities as outlined in the lease, which you gave the example earlier of it's your responsibility to shovel the snow, or
Right.
Don't have loud parties, don't leave trash out. Can you talk to some of the things that are typically included as terms and things that are not okay to require?
Well, anything can be included except for certain things, such as, and I'm glad you brought this up, landlords cannot say you can only have you in the apartment. There's actually a law, civil rights law in New York, that allows a tenant to bring in their immediate family or bring in one unrelated party and their immediate family. So the provision that says this is property leased to John Smith and John Smith only, he cannot have anyone else in there, is void, meaning it is unenforceable, it is illegal, unenforceable, and you can't put in, well, if you have another person, it's another $100 a month, sort of thing. Because then you're getting into controlling who comes in the apartment and who doesn't. And the civil rights law in New York does not allow that to happen. So what I tell landlords is you have to take into account this potentiality and rate your apartment accordingly. That's the way that it is. We had a question over here.
City of Ithaca housing code allows certain apartments, I manage some one bedrooms, that allow one person occupancy only.
Yes, there's some, what was brought, and that's the caveat, what was brought up is that some local codes may limit it. And what I say is, you can't say it's limited except to the extent of safety codes. Safety codes can direct. So it'll be a local ordinance that says you can only have one person per bedroom or two people per bedroom or whatever the rules. That's separate. I'm talking about what the landlord can tell. The landlord could only put that imposition in to say, I'll use an example. City of Ithaca code says only one person per bedroom. There's 2 bedrooms here, so the maximum occupancy is 2 for safety reasons. Yes, that could be limited, but the landlord can't say who it is or limit it in other respects. So let's assume for the moment that it's a 1-bedroom apartment, and let's say the local municipal code allows 2 people per bedroom or whatever it happens to be. But you're only renting a 1-bedroom to one person, you can't say you can't bring in another person. The law does not allow it. And it is void, meaning it's unenforceable. If you went into court and you sued the tenant to evict them because they brought another person in, you'd be tossed out because that provision in a lease would be void. So I'd say that word to the wise, take into account that there could be other people coming in and it is legally allowable. You cannot direct. Because think about this relationship. This relationship is the landlord is giving up exclusive use and occupancy of this space. You can't dictate what goes on in there. That's up to the tenant. Except we have the outer boundaries of safety and law abiding and all that stuff. You can't run a brothel. You can't do a drug trade out of that. But other than to the extent that somebody likes jazz music and the landlord doesn't, so they can't play jazz music. You can't tell people what they can do in their own home. So that's, except on the outside ranges of safety and that's legality and that sort of thing. You can't dictate it. So you cannot put in a lease, well, you can put in a lease, it's just not enforceable. Those types of restrictions. But I would handle everything. I would handle how much the rent is, when is the rent due, if there's a late payment. First of all, the late payment has to be reasonable. You can't say $50 a day because that would be, how much? $50 a day for 30 days? $1,500 extra bucks because you're late in rent. It's got to correlate it to expenses. How much is it going to cost you to carry this thing for longer? Next question.
I have a question about what you said about the landlord giving up exclusive use of the space. At our legal aid office, we have a lot of callers who say, is it all right for my landlord to show up unannounced and just walk,
Exclusive, yes, exclusive use and occupancy. And the question was, does the landlord have the right to come and inspect? And the answer is no, unless they agree to it as a part of the lease. Put that another one in, check mark in your lease. But it must be at reasonable times and on reasonable notice. So if the person says, hey, look, I'm going to be coming by every Monday at 10 a.m. to look at my place to make sure, that's unreasonable. So there has to be reasonable notice. What's reasonable notice? I don't know. 24 hours, 48 hours, 72 hours. I think that we could all agree. And a lot of it goes toward communication. Let's say you're coming to the end of the lease, the landlord wants to release it, so he wants to have somebody come and look at the place. Work it out. Tenants, you have to be reasonable as well. No, I'm in class until 1 o'clock in the afternoon. Can we work it out that you can come by at 2 and I'll be there or whatever. However you can work it out. You got to work it out. Communication is very important in this relationship. But it can't be unannounced. It can't be just shown up because the landlord has given up exclusive use. Absent any other agreement, landlords, if you don't have an agreement, you have no right to be in that apartment at any time during the term of the lease except in an emergency. I'll use another example. Let's assume it's a upstairs, downstairs apartment, and it's the Christmas break, and you have students residing there, and the person downstairs looks up, and there's water spot forming in the ceiling of the apartment upstairs. And so there's obviously a leak. Maybe they left a faucet on or a drain plugged or something, and they went home for the holidays. Can the landlord go in? Yes, only for that purpose and that purpose only. I have had situations in my long practice career where landlords have actually been sued because something has been missing from an apartment, and the only person that anyone can verify had been in there was the landlord. So landlords, if you're going in, you better have a good reason, and two, you better have somebody with you so that they can verify. I would recommend if you're going in, contact the tenant. It would be great if the tenant was still there when you went in so that you can cover your butt and make sure that it was, you know, a legitimate reason for going in. But just a general, hey, I'm going to go in and look around, unless there's agreement that allows for that, you cannot go in. You're getting rent. That's what you gave up. You gave up exclusive use and occupancy of the premises. That leads to more questions.
Oh, I'm going backwards. I have a 3-bedroom apartment that the code says can fit 4.
4 people or 4 per bedroom?
4 total people.
4 total people.
The rent
Code
for-
says it.
The rent for 3 people is $1,800.
Yes.
Can I make the rent $2,000 for 4?
Can you make the rent $2,000 for 4?
You
You
would
can
say
make the rent anything you want.
you would said you couldn't add money for an additional person.
Right. If you rented it to 3 people and then they brought another person in, you should have rented it for $2,000 for 3 people. Okay? That's the risk that you run.
So by doing that, if you're adding an additional person and they bring them in, the person is not on the lease.
The person is not on the lease who
So
gets
how
brought
do we
in.
owe them any legal responsibility if they are not signed up on the lease?
They are bound by the terms of the lease if they come in.
But if they're not on the lease?
That's their problem. They came in under the term. They come in under, they're a subtenant. So you still have the overarching tenant that is responsible. So if, for example, the person who comes in causes damage, but they didn't pay a security deposit, it's coming out of the person who brought them in.
But what happens if it's more like the day-to-day thing, say they get locked out and they're not on the lease?
If they get locked out of,
We can't let them in if they're not on the lease.
well, there are provisions that says that you can require a tenant who is on a lease to notify you within 30 days of somebody moving in with their name and address. Not that you have to approve them or anything, but that you just have a record of who it is that's in there. So that may help you to identify if there's somebody else in there to let them in. But if you don't know they're there and they say, knock on the landlord's door and say, I'm in there, my friends, I'm living there now, and the friends are on the lease and I can't get in. You say, I'm sorry, I can't let you in. Talk to your friends. You don't have an
But if
obligation to
we
let
do
them in.
agree to let them in, then we can't charge additional rent.
No. No. Unless they have a separate agreement with you, which in likelihood they don't have to because they can, their friend, the girlfriend is coming in to live, or the boyfriend's coming to live, and they have the right to do it. Yes.
So can you add a clause to your lease that does not allow them to bring others in?
Can you add a clause to the lease that says you can't bring anybody in? It's void.
Okay.
It's
So you
unenforceable.
can't charge them like we charge, mostly students, what they do, we charge an annual trash fee per occupant. If they've brought in 3 more people, so you're saying you can't charge them?
Can't charge an additional amount. Now, I say that, you are more likely to be successful if you can show that that charge that you're charging is directly related to the increase in expenses that you have as a result. I know it's difficult at times, but at least the person has a lot harder argument to make to say, okay, we charge an extra $25 a month because of hot water and heat that'll increase our bill. If you can justify that, I think somebody's gonna be hard pressed for that, but it's easier to put it in the lease that we charge, it costs X number of dollars for heat, utility, garbage for each person. We're adding if an additional person comes in because there'll be more garbage generated, more heat, more hot water generated, we're gonna charge another $50 a month or something like that. If it's not a random number, but can be related to the extra cost that's associated, you're much more likely to be successful with that sort of thing.
I'm going back a little further to the, giving up exclusive use. And you talked about, a tenant couldn't be dealing drugs or whatever, but could, it be in a lease that a tenant can't have a personal business?
Can it be in your lease that the tenant can't have a personal business or something like that?
Yeah, run out of that.
Only if it's code related
Okay.
issue. That might be zoned so you can't have a personal business or something going on. Other than that, you can't dictate what somebody's doing in their apartment.
Good time for me to follow in. So can you please speak to the regulation of childcare service, home-based childcare service in properties? And it is an allowable use of a residential property. What does the landlord have? What can the landlord limit around that? Or what can they do if that's not something they like? Case history supports the tenant, and so I'm kind of wondering.
So the question
Like
is
the landlord's
what about
rights.
if a area is zoned to allow childcare facility in a house and the person wants to do that and the landlord has some objection to it?
Actually, let me clarify. In New York State, in residential properties, it can't be zoned out. The tenant has the right to operate a childcare program. So if the landlord doesn't like it, they actually can't say no.
If the
and
landlord
case
does not
history
like it,
shows-
they cannot
Case history shows
dictate.
that the tenant would win and not be able to be kicked out if the landlord objected.
Yeah, the
So
landlord
in
can't
place-
it's the answer's still the same. The landlord can't dictate what a person does in their apartment, as long as it's legal and all that stuff. So the landlord can't dictate what somebody's doing there. If I wanted to I rented a place and I wanted to do my law practice and the landlord didn't like lawyers, well, he can't tell me what I can do and what I can't do in the premises. So the same would be true with childcare.
So if someone's in that situation, but they choose to operate that and they are not given the opportunity to renew their lease,
Someone,
in some sense,
Okay.
that landlord is speaking with their
okay.
power to not renew the lease.
So the question then comes is the landlord won't renew a lease because he or she finds out that the person is doing something in the premises that they don't like to have done. The landlord owns the property. The landlord can choose who to rent to and who not to rent to. The landlord can choose not to rent to someone. The only thing that a landlord cannot do is discriminate. And someone would say, well, having a childcare facility, that's discriminating against children. No, it's not. Discrimination is age, race, creed, national origin, sexual orientation, all those suspect classifications. So a landlord cannot refuse to rent to somebody because of their age, because of their sex, because of their national origin. They cannot do it. So they can't do that. If it's something other than a suspect classification, I don't like them because they're mean. Well, mean people are not a suspect classification, at least the last time I knew. They can choose who to rent it. It's their property, so they can choose. It's just when they're in there under a lease for a set period of time, if whatever they're doing in there, as long as, again, we go to it's legal, all that stuff, they can do it. At the end of the lease, all bets are off. It's whatever the two parties can negotiate. Question back there.
Yeah, I'm a landlord, and I had a situation similar to this where a tenant wanted to start like a massage business from the apartment.
Okay.
And I contacted my insurance company, the agent, to see if that would be okay under my existing landlord's policy. And they said absolutely not. That the tenant had to have additional insurance to cover all the foot traffic and liability, whatever.
That comes down, the question then for those out in TV land is what if whatever activities being conducted on the premises would cause extra exposure in liability to the landlord itself, then the landlord, if they were going to lose their insurance out of that, would be able to have the opportunity to either get a rider to cover it and charge that as the additional rent, or to stop that particular activity. I would include that as a part of my lease agreement that says that you can't do anything that, carry on any activities that would increase the cost of my insurance, and that any additional charge for my insurance would be would be additional rent.
But could you just say to the tenant, or even have it in the lease, that I wouldn't allow any kind of a business like that that would incur these costs to be?
You could exclude a business that would cause your insurance to be canceled as a result.
So they wouldn't be able to come back and say, I'll pay the additional money, and therefore you have to let me do it.
I think they might be able to do that. If they're willing to cover your exposure, then you can't.
Okay.
Because what do you care? Because
Yeah.
you're covered. So if we sit back and think of this and say, okay, I'm getting X number of dollars, so I expect to get X number of dollars and incidentally X number of profit as a result of this thing. If that changes because of something they're doing, and they're willing to put you in the same position that you've always been.
Yeah, the problem though was additional parking space was not available at the property. And so there were other factors that there would have been extra cars coming in, and it just wasn't feasible for that.
Well, then it gets down to deciding what the facts are and whether, and it's hard to judge every separate fact that occurs. What I'm saying is a general rule, you cannot dictate what goes on in the premises. Let me move on a little bit. I'll answer some questions about this later, but we're running out of time as it is, and so we can at least go through and finish kind of this topic area, and then we can move on to additional questions. The other thing that I wanted to get into is what happens in the event that the landlord doesn't, or the tenant doesn't fulfill their obligations under the term of the lease. And that falls into the issue of evictions. First and foremost, landlords, understand this. You cannot change the locks to get somebody out of the premises. You cannot throw somebody out of your own will. There's this relationship that was created, this contractual relationship that individually the parties cannot sever. There's only one entity that can sever that, and that's a court. A court can break that relationship. And so that is called an eviction proceeding. You cannot undertake your own eviction proceeding, whether it's actual, throwing people's stuff out on your own, or inherent, which is shutting water off. You cannot do that to get the person to leave. It's illegal. Cannot do it. What do you have to do? You have to go through an eviction proceeding, and you have to have the court sever the relationship. What does that consist of? There's certain I's that have to be dotted and T's have to be crossed, so make sure you do it right, or you're going to be starting all over again. The typical eviction proceedings are for failure to pay rent or a holdover. Someone who stays after the term expires. Let's talk about terms. First of all, a term can be anything. It could be a year, it could be 6 months, could be 3 months, could be month to month. I will tell you, the law presumes, it's assumed, absent an agreement between the parties, it's assumed to be month to month. So absent anything else. Parties can agree to longer terms. They can agree to 10 years if you want. Typically it's a year. Regardless of whether it's month to month, 3 months, 6 months, a year, 2 years, put it in writing. Even if it's month to month. So how does a lease end? Lease ends by its natural existence, and that is at the end of the term. Let's say a year. We'll just use that as our example. It's the best. A 1-year lease. It ends at the end of the year. Tenant, You have to get out. Landlord, you can get the property back at the end of the year. If the person stays over the year and you want to get out, you start an eviction proceeding to get them out. That's not our usual example, because what happens is, also, if you stay past the year, tenants and landlords, it converts to a month-to-month, absent another agreement between the parties. It converts to month-to-month. What does that mean? That means that either party, tenant or landlord, can terminate the lease on a month-to-month tenancy on 30 days notice before the beginning of a term. And that means is typically they go first of the month to the end of the month. Sometimes they'll go middle 15th to the 14th or whatever. It has to be either party, landlord or tenant, gives notice to the other party, your lease expires, and it's got to be, well, again, we'll assume a first of the month to the end of the month. Before the first of the month, either party has to give notice to the other that they will be out at the end of the month. And there is no right by either party to stay past that period of time. Tenant says, but I don't want to move, and I've been here for 5 years, and I don't want to move, and we had a lease for the first year, and it's been month to month, and it's been great, and I don't want to move, and I got tests, and I got this and that going on, and I can't move, and I don't have enough time. Tough. It's the end of the lease. Landlord, you got a great tenant. And I know from landlord perspective, there is nothing better than a good tenant. Nothing better. They pay their rent on time. They don't give you hassles. You get your check. You pay the bills. Everybody's happy. And then they give you a 30-day notice. And you don't want them to leave, because then you gotta show it again and find somebody. And you're never going to find anybody that good. Tough. You can't keep them. You only have to go the length of time. So 30 days notice before the beginning of a term. If we get to that point where the usual circumstance of reasons why landlords want their tenants to leave is a failure to pay rent, certain things have to happen. And make sure you do these and do these right. First of all, you must give the tenant, and the tenant must receive what I refer to as the first 72-hour notice. You have to give them a notice saying rent is due $450 a month. It was due on May 1st. It's now May 3rd. I haven't seen the rent. You have 72 hours to pay or get out. If the person pays, they get to stay. If the person gets out, you can't evict them because they're already gone. You could sue them for the rent for that month because they still owe it to you. Or if a tenant leaves, by the way, tenants, if you leave 6 months into a 1-year lease, you're responsible for the entire year. That's just the way it is. You're responsible for the year. So you could get sued for the rest of the year. But you have to, so in the eviction context, 72 hours, 3 days, pay or get out. Must give that first. If you don't get to start an eviction proceeding. The second step, we'll use the story, go past the 72 hours, you haven't been paid, and the tenant hasn't left. The next thing you have to do is start an eviction proceeding. And that is it's called a notice of petition. That means notice to the person of when they're going to be in court. And the petition, and that outlines your reasons to be able to recover the property. It's called a summary proceeding for the recovery of real property. In other words, you're trying to sever that relationship and get the property back. That's what the landlord's trying to do, is get the property back, cut off that exclusive use and occupancy. What you have to say is, this is the reason why I get it back. It's because the rent's $450 a month. It was due May 1st, hasn't been paid. I gave them the 72-hour notice, and they still have not vacated, nor have they paid the rent. I want my property back. And that petition and notice of petition, the notice just says when they have to be in court, gets served on the tenant. Here's another proviso. That has to be served between 5 and 12 days prior to the day that you're in court. So in other words, you have to find out when you're in court, count back 5 days, count back 12 days, and serve them in that window. If you serve them 14 days before you're in court, or 3 days before you're in court, it's tossed, and you got to start over. So you got to serve. You serve it on the tenant, you go to court on the day that the notice of petition says that you have to be in court, and the only thing the judge should hear is, this is an issue of failure to pay rent, is, okay, I have a petition here, it says that you owe $450, that it wasn't paid, it still is not paid. If, by the way, landlord, you are paid for that rent prior to court, you're out because you got paid. The tenant then says, well, I'm going to have it tomorrow. I'm going to have it tomorrow. Really, the judge has the proceeding in front of him or her that day, and if it hasn't been paid, they should sign the warrant. Now, there's some times when the parties will negotiate, and the judge say, come on. They said they're going to have it next day. I'm going to hold off on signing this warrant until the next day and make sure it gets paid. That's up to the judge to decide, but generally speaking, if it's not paid, that's what's before the court. It's owed. The landlord is entitled to get the property back. How does the landlord get the property back? The court signs a thing called a warrant. Doesn't mean somebody's going to get arrested or anything. It's a warrant for recovery of real property. The landlord has to take that warrant over to a law enforcement agency. It's typically the civil division of the county sheriff. Pay them a fee. And they will make sure that the property comes back to the landlord. What then happens is the sheriff's office, I'm just using the sheriff's office. Some municipalities used to have constables. I don't know if they do anymore. Or city police used to be able to do it. I'm not sure they do it anymore. I know the civil division of the sheriff's departments do it. What they do is they serve a notice of warrant and warrant on the tenant. And that's the second 72-hour notice. The notice of warrant says, here's the warrant. You have 72 hours. I'm going to be back. If you aren't out, we're throwing you out. And then the tenant's got 72 hours to get out. And that's all they have. Now, what will the law enforcement do? The law enforcement does not have a moving company. They won't move people out. All the law enforcement does is keep the peace. They make sure that the person is out. If they aren't, they're the ones that walk in, grab the person, and take them out. Then it's up to the landlord to clean the property out. And what does the landlord do? The landlord does something that's reasonable. What is reasonable? Depends on the facts and circumstances. Is throwing their furniture out the second-story window reasonable? No. Is finding a storage facility and having to pay for a storage facility to store their stuff? I don't know that they're obligated to do that. If, however, they can be reasonable and say, look, I'm just gonna change the locks and I'm not gonna re-rent it for another month anyway. I gotta do some work in there. I'll do the work. And the person has the opportunity, they can come contact the landlord to come get their stuff. Landlord, you cannot keep their stuff. Cannot keep their stuff. I know you're owed rent and you really want your rent, but you can't keep their 75-inch 4K surround sound audio system thing until you get your money. You cannot. You must give them their stuff back and give them access to their stuff. Can't hold it hostage. But they may contact you to get their stuff. You make arrangements with them. You go there. They move their stuff out during that period of time. But there is no obligation. The only obligation is to act reasonably. If you have no place to store the stuff, no place to put it, can't put it in the garage out back or whatever, and you have to put it out, you may have to put it out. You got to act reasonably. That's the only requirement that had. That's kind of it in a nutshell. What we're going to do now is thank everybody for being here. I wish you would all come back. Engaging crowd and asking questions. Those of you out in TV land, come join us. We are here at Cornell Cooperative Extension on the second Thursday of the month at 11 a.m. on Willow Avenue. Come join us. We do a different topic each month. We've had a lot of questions. There are a ton of questions I'm sure that we'll still go over, but some that I haven't even thought of. But if you have questions, come down. If you have questions related to this topic or any other consumer-related topic, you can contact my office, which is the New York State Attorney General's office. We're in Binghamton. We have consumer staff on that take telephone calls. You can file complaints with us related to any business merchant that you might have a problem with as a consumer. We try to mediate those problems to try and resolve them. We'd be glad to hear from you. It was a pleasure with having you all here. Hopefully that we will see you again. So until next time, I hope that you have a good day. Thanks.